it's a combination of things that come together, right? The just play the video is actually a really good metric. Yeah. All right. Continuing. Where were we? Same standard applies to motions brought under either rule. Thus, the issue presented by a Rule 12C motion is the same as that posted in a Rule 12B6 motion, whether the factual allegations of the complaints state a plausible claim for relief. Claim is okay. And then this is like, again, just talking about when you're allowed to file these motions. This is not really that important, or it's important for the law, but it's not important for talking about whether or not something is fair use, for stream. Evaluating the motion, blah, blah, blah. Judgment on the pleadings is proper when the moving party clearly establishes on the face of the pleadings that no material issue of fact remains to be resolved and that it is entitled to judgment as a matter of law. This is just saying, like, as long as we're not disagreeing with, like, major facts. So, like, if in Ethan's lawsuit he said, like, I don't know, like, and then Denims left the stream for an hour. There might be problems there that, like, and we disagree and they refuse to, like, take it back or whatever. There might be such sufficient problems there that we can't have a motion on judgment of the pleadings because we're not agreeing to the facts of the case. But we're not necessarily disputing the facts. Did you or did you not have a stream on the 31st where one of the videos you reacted to was the content nuke in its entirety? Yeah, that's true. Yes, correct. Did you or did you not... I don't know, like watch the watch and react to the countdown episode. Yes, correct. So there's not like, there aren't essential issues that we can't correct. Like we both agree these events occurred. We both agree Ethan released this video. I reacted to it on this time, on this day. We both agree that my stream was this long. We both agree about all of the important facts of the case. So we can have a judgment for motions on the pleadings. Because if the second you have to introduce new evidence and say, wait, I disagree. That's not what happened. This is what happened. Then I don't think you can even do that. This is only for the purpose of this motion. All right, continuing. And then, this is the good part. All right, guys. And yeah, just to be clear, agreeing to the facts of the case is just for the purpose of the motion. You're saying, hey, even we may not necessarily agree with everything, but for the purpose of this motion, we are open to the interpretation and the recollection of events by Ethan and his team. Let's take everything he said as fact. Let's say everything he said is factual. We think you should be able to rule. The second we start disputing things and saying, no, that's not what happened. No, I actually reacted for like this thing for this period of time for this. Then you have to go to, actually go to trial. Yeah, it's called the light most favorable to the plaintiff, correct. And that's why this appeal, depending on how this appeal goes, it might just go on for even longer. The appeal ending is not like the end of the lawsuit, technically. If I win, it probably is. But if not, it just means that we have to go to trial. Because this is just for the motion to dismiss, which is, I know some of it's a little confusing, but I hope I explained it to the best of my ability. All right, continuing. This part's pretty good. Analysis, and there is a little footnote here that says, plaintiff requests that the court take judicial notice of specific documents and records. First, plaintiff requests that the court take judicial notice of a video titled The Big, The Bold, The Beautiful, which was a reaction video to the work Bold Guy versus Parkour Girl in Haas v. Klein. This video was filed in District Court of the Southern District of New York in an action entitled Haas v. Klein. Likewise, plaintiff requests the court take judicial notice of a video entitled Bold Guy vs. Parkour Girl, which was the plaintiff's work. And it's just describing all of the works from his original lawsuit. Okay. And then it also talks about the other lawsuits. Can you do anything to get money off him for being, for bringing such a shit obvious slap suit? Well, technically, it's a federal court, so slap doesn't apply here. Slap is not for federal courts. Federal courts are just different. You can't file an anti-slap motion, to be very clear. And second, there's nothing that I can do until after the appeal. So after the appeal, I can push for legal fees back. But before the appeal, not really. Okay. Congrats. Thanks. Thank you. All right. Is there an anti-slap motion? Not on a federal level. Not on a federal level. Anti-slap is like a specific California state thing. Not a federal level thing. Yeah, it's on the state level. All right. Continuing, defendant moves for judgment on the pleadings as to plaintiff's first claim for relief for direct copyright infringement as to the nuke based on the second affirmative defense of fair use as pled in defendant's answer. The fair use doctrine is an equitable rule of reason that permits courts to avoid rigid application of the copyright statute when on occasion it would stifle the very creativity which that law is designed to foster. So the whole purpose of like copyright law is so that like there is creativity that can thrive, right? That you can work on a creative piece and that other people that like, sorry, let me correct my statement. That we incentivize people to make creative works, right? If copyright law is so stringent that you can just target anyone for making anything that's parodic or criticizing or whatever, you're like, that's the antithesis of what copyright is meant to do. Copyright law is meant to help people be creative, not to hurt it, right? And so that's why there is a specific fair use doctrine. All right. Continuing from here. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. And here are the 4 factors. Now, please take a look and note that intent is not a metric here. The 4 non-exclusive factors courts consider when determining fair use are the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. So what was your goal when you made your work, when you made your derivative version of your work or whatever? The nature of the copyrighted work. So like, is it a mostly factual statement? Is it a news article? Is it like a short film about, I don't know, stuff that short films are made about? The amount and substantiality of the portion used in relation to the copyrighted work as a whole. So how much was used and whether or not the correct amount was used. The effect and use upon the potential market for or value of the copyrighted work. Now, what you guys need to understand is all of these other factors, I think except for 2, rely heavily on whether or not the work was transformative. Because think about it. If the work was transformative and you've created a brand new product, the effect on the potential market becomes much less important because it's such a unique new product. So whether or not the work is transformative is the most important thing. And make no mistake, the judge says that the work is transformative. But let's continue. And again, notice that at no point here in these 4 pillars does it say whether or not you said you were going to do anything, whether or not you said something. All right, Dr. Seuss versus Comic Mix. And then this is like, I've seen this case so many times at this point. Is the third one the one you failed since you used the whole video obviously very transformed? No, actually, because I used the minimum amount that I was meant to use for the purpose of debunking a hit piece. The one that I didn't even lose it. It was neutral. Was the nature of the copyrighted work where the judge says, you know what, there are enough creative elements in Content Nuke that it deserves copyright protection. All right, great. That was actually the only pillar that was even remotely close to losing on. The rest of them were all victories. So, and you guys have to understand, this is not a pass-fail system. This is a, you take all the factors together and it's like this holistic approach and you decide based on, it's very like vibes based. It's very, you know it when you see it. 4 pillars, sister. Denims, I recognize 5. Mashallah. Yes, I made the judge into a snarker. This is true. I did do that intentionally. Maliciously, intentionally snark the judge. I have to say, the amount of like stupidity on the internet where people are like, well, I'm smarter than a federal judge. It's like, yeah, well, this judge doesn't know shit, unlike me. I spent all of my hours posting comments on legal mindset videos. Yeah, bro. Yeah. Okay. All right. And then continuing. Oh, where were we? Yes, this is very, very, very important. What you guys need to understand. Fair use is a flexible concept and its application may well vary depending on context. In fact, the courts require, or not the law effectively states that the judge's ruling on fair use shouldn't make decisions off of like individual like facts, or maybe that's poor phrasing on my part. I want to correct that. That there is no one individual thing that sinks or wins a fair use case. So watching all of it could hurt you, but it's not like the end all be all. You have to look at everything combined, right? It's like if you went to the store and got like a cake and like the topping was really good, but the cake was a little bit dry, but the frosting was the best you've ever had. And overall, like the flavor, you're going to judge it when someone tells you to give a score for it. You're not like, well, it gets a 1 because it was dry. It's like, well, what about like all of it together? Like the aggregate, all of the parts together combined, what would you give that? And that's the same idea here with fair use. It's not any individual little thing. It's all of the aggregate facts combined. Does this feel transformative? All right. My fat ass perked up as soon as you said cake. Dude, real. Oh, God. All right. Totality of the circumstance? Yes. Yes. All right. Where were we? Additionally, when copyrighted work and the alleged infringement are both before the court, capable of examination and comparison, non-infringement can be determined on a motion for dismiss. And then we have purpose and character of the use, transformative nature. Defendant moves for judgment on the pleadings in part because of the transformative nature of her use. That's me. The first statutory factor examines the purpose and character of the use, including whether such use of a commercial nature is for non-profit educational purpose. This factor has taken on a heightened significance because it influences the lens through which we consider two other fair use factors. The central inquiry under the first factor is whether the work is, quote, transformative. The term transformative does not appear, yet it permeates copyright analysis. Transformative works add something new to an existing work, endowing the first with new expression, meaning, or message, rather than merely superseding the objects of the original creation. So I'm arguing I added new things to that work. I stopped the video multiple times to say, what the fuck is this guy talking about? This is not factually correct. Wait a minute. This isn't what happened on the Galaxy ship. Wait a minute. That's not what... Wait, the UN actually did not find that in their report. What the fuck are you talking about? Also, your editing is trash and this feels like a middle school project. Also, like, you're the fucking Arabs or whatever. Well, that was before that, but you guys get the idea. There is a new experience occurring watching that compared to not watching that. Right? And that's what we argued, and that's what the judge agreed with. The court in Campbell held that the central purpose of this investigation is to see whether the new work merely supersedes the object of the original creation or instead adds something new with a further purpose or different character. And this is why it's so bad that in Ethan's original filing, he says that I add something new, that my goal is to make it a different product, one that in fact does not push people against Hassan's anti-Semitism and anti-Israeli rhetoric. Continuing. Altering the first with new expression, meaning, message, it asks, in other words, whether and to what extent the new work is transformative. In contrast, commentary that has no critical bearing on the substance or style of the original composition, which the alleged infringer merely uses to get attention or to avoid drudgery and working up something fresh, the claim to fairness in borrowing from another's work diminishes accordingly. So, like, putting something on the screen and then, like, doing my nails and saying, like, I like turtles or whatever. But as you guys know, because you guys were there, watching the content nuke, I'm constantly reacting and saying, that's insane. Like, I don't even know how Ethan could come up with these ideas. This is so absurd. Yeah, no, actually, I don't know why you would ever think that about this person and this person. No, that guy is not a Hassan fan. That guy's a Sneeko fan. Are you kidding me? And then, by the way, I was like totally right about that. And then they just like literally deluded themselves into thinking that I was wrong. Because he was trying to take a picture with a guy he just found out about 5 minutes ago. But there's so much of my commentary would make no sense and would not be able to exist without the original work. Whereas if I had gotten on and I was like, yeah, my favorite thing to eat is like steak. Why are you playing this video? Why do you need to play that video if you're just going to talk about steak all day? My commentary was directly related to the original work. It was directly related, and I was directly discussing and responding to stuff that he said about Israel, stuff that he said about the United States, stuff that he said about Hassan, stuff that he said about Hezbollah, stuff that, like, all of these things, I took them and tried to make something new out of them. Okay, continuing. Moving on. The court deems defendants' use as transformative. Yay! So anyone, by the way, I've seen quite some illiterate morons in the both H3 subreddit, but on Twitter, being like, the judge literally said her work wasn't transformative, but gave her the win anyway. It's like, did you read this? The court deems defendant's use as transformative. Throughout the live stream, defendant provides commentary pertaining to criticism of the nuke. Defendant contends that the nuke resembles a high school video project or a middle school project. She complains about the documentary's editing and that the video treats the audience like morons and tries to trick them. The complaint states further that she frequently makes comments that are later contradicted by the nuke itself. And then here is this. Notably, the fair use inquiry does not ask whether the criticism or parody of the copyrighted work is just or accurate or mean-spirited, but simply whether the use is of the kind that copyright is designed to protect. If I went on stream and I watched Hassan's broadcast and I said, his head is way too big and it bothers me, that would be a factually incorrect statement. That would be protected with fair use. You don't need to make statements that are accurate for them to be defended under fair use. Fair use is only asking whether or not you are creating a new product and transforming a work. Now, all of us can look and be like, are you crazy? Are you blind? His head is clearly way too small, and that's why it should bother you. But that doesn't matter. Whether or not the statements are correct, whether or not they are factually correct, does not matter. You can say things that are incorrect, and that's completely fine. And you can say things that are disparaging, and that's completely fine. As long as it's not defamatory or slander or libel or whatever, totally fine. In legalese, it doesn't get more explicit and emphatic than beginning a paragraph with the court deems defendant was totally in the right. Yeah. So again, that's why like his original filing is very bizarre, like admitting that I'm frequently commenting about things, but they're later contradicted. It's like fair use doesn't care whether or not they're contradicted later, which by the way, they weren't. It's just like another, a lie in the pile of lies. But it's just not why. So yeah, 1 second. Also just proves that you didn't pre-watch the video. Yeah, but you don't need to pre-watch content. Also, fair use doesn't say anything about like an argument that I feel like I've seen Ethan talk about, and also he said it in his Instagram story, but fair use doesn't ask, did you wait like, okay, so this is what I mean when I say like fair use is supposed to be, flexible, and that you have to balance all of the factors, and there should not be any particular rule that's rigid when it comes to fair use. So saying like, well, she reacted to the video too soon after the launch of the video. First of all, that has nothing to do with whether or not the work was transformative. And make no mistake, the transformative nature of the work is what matters more than anything else because it impacts two of the other factors, the third and the fourth. Okay? And you don't want fair use that's like, you have to wait at least 30 minutes before watching a video. You waited 29 minutes? Yeah, no, that's no good. That's no good, yeah. So this is what I mean when I talk about fair use being flexible. It's you judge everything together and get a like feeler, or you vibe check it. Legally violate the L. Denims Wood story. Yeah. All right, continuing. Where are we? You have to wait 1 week, and you have to pre-watch it, and you have to take notes. It's like, that's just not, yeah. You transformed it, but too soon. No. It's just not, it's not a pillar of fair use. It's not like, did you wait enough time to do this? It's just not the case. All right, where were we? The court finds defendant's criticism and commentary within the live stream video to demonstrate the following telltale signs. Oh yeah, wait, I think we went up a little bit too far. Sorry. My apologies. We were here. Yeah, but simply whether the use is of the kind that copyright is designed to protect. finding, and then it cites Weinberg versus Dirty World, where this guy is like criticizing this random like model, and he says like, every time I saw her, I thought she looked super ugly and awkward looking and wondered how the model could get married to that rich guy and be a model. This is just to say your statements can be mean. You can make mean statements. That's protected under fair use. It's not like, oh, you made like 3 mean statements. Yeah, you're fucked. You're legally squashed. It's just not, it's not how that works. All right, continuing. Defendant offers other criticism of the subject documentary during her live stream. Following one of the documentary creators' criticism of Piker's apology of China's genocide of the Uyghurs, defendant comments on the treatment of the Uyghurs and, quote, two, quote, so much of American media is focused on pointing out how evil China is. 3, stating that disabled Americans lose benefits when they get married. 4, incarceration levels in the United States. I already talked about this earlier, but you guys understand now what I'm talking about. Stating that, Additionally, during the live stream, defendant challenges Klein's perception of Piker's sentiments regarding the interaction between the imports and the fleeing of Jewish people from Israel. Yeah, we went on a whole tangent, I remember, about Morocco, and how like Vichy states are like, I'm not going to relitigate it. You can actually go and see it. Disputes Klein's accounts of the events and of the occurrence of sexual violence of hostages. Critiques Klein's discussion of Twitch's enforcement and moderation. Because, by the way, Twitch's moderation policy is if you have a lot of viewers. Oh, hi, Oxy. I'm so sorry. I've been working like for the past 2 days straight. I'm going to send them right after stream. I'm sorry. Because they haven't been sending me. Sorry, guys. We went to Anime Expo. We took so many cute pictures, but I haven't sent them to Oxy because I'm fake and cringe. And also I'm gay. That last one's not related to anything else, but all right. Continuing. Where are we? Where are these clips your side submitted, or did the judge have to watch the whole reaction? These are not even necessarily clips. This is stuff that Ethan Klein put in his original filing. Do you understand? Ethan Klein, in his original 70-page document that he filed, he said, and you know, another thing, Denim said this, and another thing, she kept talking about how disabled Americans lose their benefits. And you know, she also said this, and she said things that weren't right, and also she said this. So right now, the judge is literally quoting the original complaint. That's what's being cited here. The original complaint is being cited here. That's what this says over here, where it's like the constant citations. Yeah. It's like he's talking to like a chat and not a judge. Well, I think that's why, do you guys understand what I mean when I say that like, it feels like this filing was only meant to see like the eyes of the public. It wasn't meant to see an actual court. Because I don't understand what the strategy is to show the court all of the ways where I said things and reacted to things and responded to things. Makes sense though, because I guess he kept showing the lawsuit and yeah, I mean, he did show the lawsuit a bunch of times on stream. So I don't know. I do think it was like pretty good content for a little bit. All right, continuing. Let's see. Discusses her perspective on Zionism and Judaism. The court finds the defendant's criticism and commentary within the live stream video to demonstrate the following telltale signs of transformative use. 1, to further the purpose or further purpose or different character in the defendant's work, i.e. the creation of new information, new aesthetic, new insights, and understanding. And 2, the use of quoted matter as raw material instead of repackaging and merely superseding the objects of the original creation. So you know what's kind of funny? Asmongold's reaction to the, or even XQC's reaction to the content nuke would be much weaker under fair use. Because as you would imagine, saying based and saying yeah based, yup based, you're just repackaging the original work. For me to see something and say, what, this doesn't prove that there was systemic sexual violence, that it was used as a method of violence, what the fuck? No. Do I believe that it happened? Of course I believe that it happened. But there is a big difference between that and pretending like there was a grand scheme operation by Hamas to do these actions. Versus, because there's literally the UN report showed otherwise. Versus Israel and the IDF prisons where they literally have shown sexual violence to be a form of violence and torture against Palestinians. I am taking this new work and I am taking this raw material and I'm using it as an opportunity to provide information and to provide factually correct statements. about X, Y, and Z thing, right? Whereas, as you would imagine, if I was to watch the video the entire time and go, yeah, based, yeah, based, yeah, based. Do you see how that seems a lot closer to simply repackaging the work? And that's what fair use is asking. It's asking, what was your goal and did you achieve that goal? Now, Ethan concedes the first part by saying her goal was the exact, complete opposite of my goal. And then did you do it? Yeah, here are all of the instances of you doing exactly that. Continuing, the undisputed... and then here we have a little footnote. Defendant provides additional timestamps for defendant's notable instances of pauses for commentary, reaction, analysis. And there's a bunch of timestamps here where I pause that are particularly juicy, where I say a lot of things. All right. And other than the obviously interspersed pieces here and there. Continuing, the undisputed purpose of defendant's live stream is to contest, criticize, and mock the plaintiff's message, which the courts have found weighs in favor of fair use due to its transformative nature. Think about it. Inherently, when you're watching a video, if you're reacting to a video, or maybe when you watch React streamers react to videos, they have a lot more to say when they disagree with what's on the screen. So if I watch Ethan's video and I disagree with the majority of it, and the entire time I'm like, yeah, this is wrong, this is bad, this is dog shit, here's why this is dog shit, let me pull up these articles, let me show you guys these. There's a lot more to add. Versus when I watch like a More Perfect Union video, it's like, yep, that's true. There's very little to add to that other than saying, yeah, they're totally right about this. And yes, the billionaire pedophile class is actively trying to make your life worse. I agree with the sentiment. So yeah, fair use in general has found that when you fundamentally disagree with an original work, it becomes more transformative, which again, like think about it logically for a second, obviously. And then they quote Ethan Klein's lawsuit, see Haas v. Klein, finding that the first factor weighed in the defendant's favor as the defendant's reaction video was quintessential criticism and comment. Finding transformative use where the host reacted to and commented on the original videos. This is a separate one. All right. Man. Oh, tough. Also really funny that the majority of the people who agreed with the nuke only watched the nuke and at most watched some clips of Denims' stream, almost like they appeal to different audiences. It's almost like they are different markets. That's crazy. It's almost like the type of person that wants to watch a streamer pause 220 times or 221 times, over 200 pauses, doesn't want to watch the original work as it exists. They want to watch someone debunk it and laugh at it and make fun of it. I know I wait for streamers to watch videos because I want to see them react to it. I'm like, dude, I can't watch this slop on my own, dude. No, I need someone to package and explain all of the things that are wrong with this because I know there's a million things wrong with this. Okay, someone counted? Yes, me. Okay, me and my legal team. Legal squash. Is Klein going to have to pay your legal fees? Was this filed in a state with SLAPP laws? This is a federal court. Anti-SLAPP does not apply to federal court. Anti-SLAPP is not something that can be pursued in federal court. Therefore, I cannot pursue any anti-SLAPP motion. Okay? First and foremost. Second, he did say that he was going to appeal it. So I cannot attempt to, I mean, I can, but it's not worth it right now because it's just going to, TLDR, I'll just make it really simple. You would pursue legal fees after everything is done, after the appeals are done. So that won't be happening anytime soon. If you do want to support me and help me fight the appeal, if you would like to help me and support me in fighting this appeal, I don't know how long the appeal will last. It is a federal case. It is a federal court. And federal courts, a year for a federal court is kind of a crazy fast turnaround. So, yeah, if you'd like to help me fight for like presumably maybe the next year to fight this appeal, you can donate to my GoFundMe. And it would mean a lot, and I would really appreciate it. And I promise to continue being as transparent as possible with everything and to keep you guys in the loop anytime there's anything new, just as I've been doing since day one. What can he do after he loses the appeal? Nothing, really. I mean, you can technically, so appeal systems, you can appeal to the appellate court, and then the appellate court would rule. And then after that, if they rule in my favor, you would request, I believe, to appeal to the Supreme Court. But the Supreme Court doesn't hear the vast majority of cases. There's no, I'm sorry, it would be insane for him to appeal to, that's why most people don't even bother. Appealing to the Supreme Court, and the Supreme Court's like, we're not hearing this shit, dude. I'm sorry. We're not hearing this shit, man. No. The Supreme Court hears very, very few cases. So realistically, it's this one appeal, I believe. And I think you can appeal again if there's like major problems in the filing. But that doesn't exist anywhere. So he would be appealing so that an appellate court can review the decision of the lower court. So yeah. When are you unboxing a cigar for a generational pack watch? Dude, I did. So I actually made a video, chat. Pack content on. Stop speaking. I did. For people who missed the video, I'll just play the very beginning. Oh, hey there. It's your... God. It's a big-ass cigar. I did go to a cigar shop and say, hey, what's the most comically large cigar that you have? I need it for a prop. And he said, yeah, come here. He's like, this good? Like, you got anything bigger than that one? He's like, what's this? I'm like, yes, perfect. Yes. How much did it cost? It was actually like really cheap. It was like $17. I don't know anything about cigars. It was actually really cheap. Yeah. It was probably a really shitty cigar. Every time I accidentally inhaled.
Can't do fucking shit.
I forgot about that alert. Farmers and bigger than 10 gift subs. I would accidentally inhale because the only thing I smoke ever are like joints once a month, maybe. I'm like, I don't smoke, chat. Like, you aren't supposed to inhale. Yeah, that's why it was bad. So like, I'm so used to only smoking weed, so I would accidentally do it, and then I'd be like, no, you aren't supposed to. I know you are not supposed to. I know that. I know that you are not I know that you are not supposed to. Did you guys hear me? I said, I know that you are not supposed to. And then I would accidentally, that means doing something by mistake. I would accidentally inhale. And then I would start coughing up my fucking lungs and being like, please. I'm not really into streamer drama. Can someone explain to me, like, I'm 5 what this case was about? Yeah, well, first of all, I do have an 8-minute video if you just want to. Oh, it's 8 minutes on the dot. But I do have an 8-minute video if you want to watch it. If you want to. But I'll give you like a minute breakdown. I watched a video from Ethan Klein, and I reacted to it, and then he sued me for copyright infringement. And then I fought him in court, in federal court, and a judge recently ruled that it was fair use. And my reaction was fair use. And yeah. So Ethan lost. Ethan lost his court case against me. So yeah. And now he's appealing it. Motion to keep the crown at all times. Yeah, but the fucking crown falls off my head so often. But yeah, I did go into the cigar shop. I was so stressed walking into the cigar shop. Everyone's watching, like, it's like an actual like cigar lounge. I felt like I was like, can I just have one for a prop? I'm making a video. I'm a poser. I don't smoke. Oh, God. Could have gotten a prop one on Amazon for like $2. Well, but I wanted to actually smoke it. You know? I wanted to actually smoke it. I wanted to actually get a smoke shot. You know, that's the whole appeal. I want to, like, you can't fake smoke a fake cigar, right? All right. You should have smoked weed and then the rest of the video going, and giggling. Do you still have it or did you finish it? Do you see how enormous this thing is? Did I finish it? We are seeing Denims in a very Cuban time in her life. God. That would take a day to finish. And also, I don't smoke, okay? I don't like smoking. And also now everything smells like smoke. My clothes still smell like smoke. My hair smells like smoke. So I have to like full-blown shower and like wash everything. It's brutal, man. Like, I'm like, I just want to get the fucking smoke. I've brushed my teeth like so many times and I still am tasting the smoke, dude. I can't. Oh, but anyways, all right. Where were we? Right. Continuing. I hope that explains some of that stuff. Denim's literally complaining my smoke was too loud. Dude, I know. I've had a friend who worked in a cigar shop said that 9 out of 10 sales are either one-time celebration or as a prop. Okay, phew. I was like, I hope he doesn't mind. I just want you to a cigar. I want a big cigar so I can smoke it for a bit. All right. Where are we? Right, continuing. Okay. Back to so the judge quotes Haas v. Klein and says that when the purpose is to contest and criticize, that weighs in favor of fair use. The facts here closely align with those in Stebbins v. Alphabet. So Stebbins is this case that I was talking about earlier where it's a pretty recent case. This guy on YouTube made like a 3-hour Fallout video essay. And some people, some like podcast or whatever, they reacted to it and they called it poo-poo trash. And he sued them and said, you guys watched my whole video and you stole it and I would like to sue you. And the court said, effectively, hey, a live stream is a very different experience than a video. Also, they paused a bunch. Also, they had a lot of commentary. They skipped around. They went back. They criticized it thoroughly. So it doesn't really matter that they watched the whole thing. In fact, for the purpose of what they were trying to do, which is, debunk your video, it was they used the correct amount. They did not use more than needed. So, yeah, that's fair use. So we cited this case, which was, kind of a recent development. And I'll just read out what the judge says here. In Stebbins, thank you for liking the fit. Thank you. I appreciate it. I actually tried a bunch of fits, but since I have purple hair, nothing was working except... So I had to go specifically get something purple to make it work. Okay, back. Fucking React Andy over here. Can we get back to the fucking document? Can you play the fucking document already? Jesus. The subject video created by the plaintiff provided the plaintiff analysis and opinions regarding a video game. My life is like a video game. The live streams, however, provided commentary on the subject video as well as several hours regarding other videos produced by the plaintiff and his comments thereon. The relevant live stream in Stebbins paused and commented on the plaintiff's retrospective with the purpose of reviewing or mocking the video. The criticism is at the heart of the fair use doctrine. It would lose meaning without the reproduction of the plaintiff's video. See Andy Warhol. Noting commentary or criticism that targets an original work may have a compelling reason to conjure up the original by borrowing from it. As in Stebbins, defendant's livestream provided commentary on the nuke and sharp criticism of the claims made within the documentary. So, I'm trying to think of a good example. Do you understand how, if I wasn't watching the video and instead I was just getting on stream and talking about it, the criticism that the work feels like a middle school video project or a high school video project, it falls a little bit flat if I don't show you guys what that looks like. I have to show you guys this cringy ass editing and this bizarre direction and then be like, dude, this is what are you doing, man? Or saying I don't understand why he's trying to trick people and make them think this and this and this and whatever. You're taking from this original work to create something new. And sorry, I was thinking about, there's a tweet I just remembered in my brain about how the nuke backfired in the most hilarious way. And that statement just gets truer with every second. Jesus fucking Christ. Don't say Andy Warhol was the OG free use king. Don't say that. What was I trying to say? I was trying to say something else. His claims are so insane, the only way you can make it believable is if you actually show him saying it. Well, that's another thing. The number of times that when I haven't shown someone saying something and they're like, that person didn't say that. It's did literally say that. What the hell? At this point, I literally show people saying the thing so people can believe me when I say that they said that thing. I mean, do you guys remember the fucking Giardia thing? People literally didn't believe me. And they were like, you made that up. And I'm like, look at the video. He's the one who said it. Dude, what the fuck? No, you made up a lie. It's all right, man. I don't. Okay. So continuing, and then where are we? Conjure up the original. As in Stebbins, defendant's livestream provided commentary on the nuke and sharp criticism of the claims made within the documentary. Throughout the livestream, defendant often paused the nuke to offer spontaneous reactions, engaged with her audience through a live chat, and provided real-time commentary interspersed with tangential discussions. And this sort of goes into how this is a different viewing experience. If you had a question for someone who was using the nuke for the purpose of debunking it, right? And or you had things you wanted to talk about. You can't really do that in like the comment section of a video, but you can do that in a live stream. So I'm sure there were lots of people that tuned into my live stream to be like, dude, I don't even know why Ethan is making this claim. Like, here's the article that literally shows the opposite of this. I know I've been in chats specifically because I know that what's being watched is like nonsense. And I'm like, no, you got to see something. You got to see this. This is insane. Or because people are watching and are like, I know this is insane. I want to see everything that is insane, or maybe the things that I don't know that are. And again, the live stream is a different experience, and the chatting makes it a different experience, and the work is transformative even without all of that. McMorrow just dropped out as of 5 minutes ago. No, we just pack watched that shit, man. Here today, gone McMorrow. I'm glad so many people are celebrating. Denims addressed me live in real time. Okay. You have been addressed. Legal filing repeatedly referring to a shitty YouTube video as the nuke is really illustrated of our absurd reality. Yeah. All right. Continuing throughout the stream. Yes, yes, yes. And then these are multiple parts that show like me giving a good deal of criticism or commentary or reacting to chat messages. So like from 148 to 150, I just sat there and yapped and whatever. But there's like plenty more. Okay, continuing. Further, the courts have recognized that the differences in viewing experiences and the uses weigh in favor of finding a fair use. Because defendants' use of copyrighted material served a completely different function than that of the plaintiffs, this first factor weighs in defendants' favor. The difference in viewing experience here is undisputed. Indeed, plaintiff states, indeed, Ethan Klein himself states where the nuke seeks to expose how Piker radicalizes on people online to be anti-Semitic and anti-Israeli. Denims attempts to use the nuke for the exact opposite purpose, to radicalize our audience to be anti-Semitic and anti-Israeli, along with defending Hassan. Now, again, what was your purpose and how well did you achieve that purpose? My purpose was to do this, as is conceded by the plaintiff. And I would say after 2 hours of additional commentary, I achieved that purpose. In opposition, plaintiff presents unsuccessful arguments. First, plaintiff cites Fontbrunn, I don't know this case very well, for the proposition that the purpose of the, that the purposes of plaintiff's video and defendant's live stream overlap to undermine defendant's transformative argument. Here, plaintiff has conceded that the purpose of both videos do not overlap by stating where the nuke seeks. So basically, here's a timeline. I file my motion to dismiss. Okay, after we file the motion to dismiss, they had time to respond. They responded by saying, I'll give you a short TLDR. Nuh-uh, we didn't mean that when we said it. Listen, when we said that she was using it for the opposite purpose, we were just kidding about that. We were joking. We were kidding. We didn't mean it like that. We didn't mean it like that. And then we responded saying, no take backsies. And here the judge says, sorry, no take backsies. Sorry, you already conceded this. You don't get to unconcede this. You don't get to take this back. You don't get to say later, wait. No. The purposes overlap. I know we just said 2 seconds ago that they used it for completely different purposes, but we didn't mean it like that. We meant it in the way that would win the case, not in the way that would lose the case. Can we take it back? And then the judge said, no, you already conceded this, saying where the nuke seeks to expose how Hassan radicalizes people online to be anti-Semitic and anti-Israeli. Denims attempts to use the nuke for the exact opposite purpose. Additionally, the two subject videos are disparate from the subject works in De Fontbrunn, which did overlap in nature. And then it talks about this work, the Picasso project and the subject photographs both presented the works of Picasso with the shared purpose of documenting Picasso's works. As previously established, the subject videos in this matter do not share such an overlapping purpose. My goal in showing Ethan Klein's video on the screen at all and reacting to it was not to say, Ethan Klein is so great and amazing. Look at how great his video is. I would like everyone to look at how this video is amazing and incredible. No, I put it on screen to be like, and this is wrong, and this is wrong, and this is cringe, and this is wrong. And so you can't make the statement, the definitive statement, that it was for the exact opposite purpose and then take it back. Which, a little comedic, but the same thing happened in the Stebbins case. The filing in the Stebbins case, that guy did the same thing where he said, no doubt, it is transformative, but I didn't like it. And then he was like, wait, I take it back. I was kidding when I said that. And the judge was like, no take backsies. Just dropped out. Yes, correct. And now the fucking Arabs are going to win. So he sued you for defamation? No, he sued me for copyright infringement. And I just won because fair use exists. Get these shirts for legal fundraising. Oh my God, these are so cute. I should put out some merch, honestly. We should do some merch. I know I've said that 40 times, but Denims McDonald's just dropped out. Nice. Alrighty. Continuing. Previously established. The subject of videos in this matter did not share. Blah, blah, blah. Okay. Second, plaintiff cites this other case, Maya Mag, for the proposition that the defendant engaged in wholesale copying sprinkled with spoken commentary, which the court found at best minimally transformative. Defendant's live stream went merely... Sorry, this is the most important thing, okay? A lot of people seem to think that, like, I keep seeing this fucking cope posting. I don't know, I guess, what other cope there is. And a lot of the people online that, like, don't like me are also delusional, I think. Because I respect the people that are like, listen, I don't like Denims. Her camera's too big and it bothers me. But she did win her court case. And she's hot as hell. It's like, you know what, man? Speak your truth. Speak your truth, bro. Speak your truth. But the people that are like, no. Oh, so what? You could just watch a Disney movie and say nothing? And that's fine. It's like, did you read the filing? It's not that long. You guys agree. Most of this filing is like, these are not difficult documents. Some court documents are really dense and are actually really difficult to parse through. This document is written in pretty like plain language. If you know all of the details of the case, it's actually not that hard to read this document. It's also really short for a legal document. Sure as fuck isn't the 70 pages I had to read. But here it literally says, defendant's live stream went beyond merely reproducing or supplanting the nuke. However, rather, as set forth above, the live stream incorporated real-time commentary, criticism, and analysis that altered the purpose and character of the original work. Accordingly, unlike the defendant in Monch, the defendant did not simply repackage or republish the underlying work with incidental commentary, but instead used the work in furtherance of a distinct, expressive purpose, which it literally says, nuh-uh, no. There is not wholesale copying sprinkled in. Oh, sorry, with sprinkled in commentary, excuse me. That's the end of that sentence. Have you considered increasingly larger crowns? I did have some other contenders, but this one is so heavy and it bothers me. Like it kept slipping off my head and it's so heavy that if it fell on my foot, I think it would like fucking cut me and it would bruise me. Heavy is the crown. That real gold. If you think I would be fundraising, but I could buy this like fucking 2-pound real gold crown, you've lost your marbles, man. The marbles are gone. Not glue it to a headband. Bro, you are overestimating my commitment to the bit. And also, this thing is not that easy to hot glue. As someone who's hot glued a lot of things, they've got like a little string. Whatever. I'm talking about this. 24 karat, real. Yeah, now we know where all the donations went. She bought a big crown and it bothers me. So, continuing. This is one of the few parts in this document that's different from the tentative ruling. So, during oral argument, so this was the hearing that I went to, plaintiff argues that due to defendant's hate watching of the nuke, the entire purpose of Denims' watch party was to hate watch TEI's work without giving any benefit to TEI. Plaintiff provided this argument to diminish defendant's claim of transformative use. As in Stebbins, defendant's livestream provided commentary on the nuke and sharp criticism of the claims made within the documentary. Although the court finds some merit in plaintiff's position regarding hate watching, it is insufficient to negate the transformative nature of defendant's work. Defendant often paused the nuke to offer spontaneous reaction, engage with her audience through a live chat. Defendant provided real-time commentary interspersed with tangential discussion. Defendant did not simply repackage or republish the underlying work with incidental commentary, but instead used the work in furtherance of a distinct, expressive purpose. And then there's a footnote saying, hate watching can be understood as the intentional consumption of an expressive media, not for enjoyment, but for the purpose of criticism as the viewer remains engaged, despite finding the content objectionable. And And basically the judge says that doesn't matter because it's transformative. So may I suggest an analogy briefly? If the only reason you were buying Mr. Pibb was because you hate Coke, Mr. Pibb didn't do anything wrong for that. They wanted to make a soda. They just wanted to make a soda that people would like. And then they made a soda that people would like. It's a different product with a different formula. So it doesn't matter whether or not you as a consumer are like showing up to the Mr. Pibb store and saying, I just want you to know, I only buy your sodas. I don't even drink your soda. I only buy it to stick it to Mr. Coke. All right? Mr. Pibb's like, all right, what the fuck you want me to do with that? That'll be $2, sir? Okay. What matters is whether or not the product is different. And the 4-hour live stream where I'm sitting there and pausing and reacting and calling the video bad is a different product. So the transformative nature of it is so important that it doesn't matter if there are people in here or there were people in there that just really fucking hate Ethan because my work was transformative. The work is new. Can you imagine what an insane precedent that would be, by the way? You watch a streamer and you're just watching that streamer because you hate some other streamer. And now that streamer is like, they're legally squashed. It just doesn't even, it's like, it's so nonsensical. People should be able to recognize on its face how fucking stupid that is. And yet, here we are. I got lost in the analogy, I think. Don't worry about it. Continuing. Further, plaintiff presents a piecemeal argument during oral arguments and asserts that defendant, through her reaction video, could potentially demonstrate fair use as to pieces of her video, but not to other pieces. Plaintiff doesn't present authority to support this argument. The court also doesn't find authority or a bright line rule to endorse plaintiff's argument. Indeed, in Stebbins, with respect to the subject, the defendants viewed the subject video for seconds at a time before pausing and reacting to respond and critique the subject video. The court in Stebbins did not hold that certain pauses or portions of the video accompanied by defendant's criticism constituted fair use while others did not. Instead, the court found that the subject's live streams to be highly transformative work. Again, it's about talking about the entirety of a work. Your Honor, will at 1 hour and 10 minutes, it took her a minute to pause and say something. Okay. This isn't like, oh, you made one fatal flaw in this exact moment, and so now you're legally squashed. It's about the entire thing. Does the entire work collectively, cumulatively feel like something new? Not whether or not some of it was transformative and other parts weren't, and some of it was fair use and other parts weren't. So yeah, continuing. For the foregoing reasons, the court finds defendants used to be transformative. This felt so good to read the first time, guys. I'm not gonna lie. Okay. We're getting through this document. We're almost through. B, commercial use. This is the second pillar of fair use. Okay. And this is the pillar that basically asks whether or not you are allowed to commercialize your work and whether or not your work should have copyright protections. Okay. The second part of fair use involves whether the new use is commercial, whether the user stands to profit from exploitation of the copyrighted material without paying the customary price. Critically, the more transformative the new work... Wait, is this the right one? I might have been mistaken about it being the third one. Let's keep reading, and then I'll know for sure. Critically, the more transformative the new work is, the less will be the significance of the other factors like commercialism that may weigh against finding of fair use. The commercial use factor also concerns the degree to which a new user exploits the copyrighted work for commercial gain as opposed to incidental use as part of a commercial enterprise. The court in Draft Express found that even if the relevant video were considered at least partially commercial, its transformative nature offsets the significance of any commercialism. So basically, it would be crazy that if you criticize something, you couldn't make money. If you're fully transforming it, making something new, you can make money doing that. Reviewers would all be out of business. I mean, critics would be out of business, right? Hassan would be broke and homeless. Actually, the entirety of the slop tubers on YouTube, none of them would be able to make money. None of them. Here, defendant contends that her use was not sufficiently commercial enough to outweigh the transformative nature. As defendant is a live streamer, she's eligible to receive subscriptions, donations, and advertising revenue during her Twitch broadcast, regardless of the content nature of her use. So there is no doubt that there was a commercial use of the subject work. Basically, yes, correct. While I was live streaming, people were subbing, and people could sub. See generally Wall Data Inc. versus Los Angeles County Sheriff's Department. A commercial use is demonstrated by showing that repeated and exploitative, unauthorized copies of copyrighted works were made to save the expense of purchasing authorized copies. Although Whistle's social media presence may serve to promote its business and indirectly boost revenue, the commercial use factor concerns the degree to which the new user exploits the copyright for commercial gain, as opposed to incidental use as part of a commercial enterprise. The defendant's transformation of the original work heavily outweighs the commercial nature of its use. Because defendant's use of the clip is transformative, the fact that Jersey Boys is a commercial production is of little significance, citing a different case. Finding that a work's commercial qualities become less important where use is highly transformative. So when the work is transformative, okay, this was the wrong one, by the way, I was mistaken. This factor was in my favor. It was the next factor. My apologies. Basically saying, yes, Denims made money on her stream. Yes, people sub to her stream. But that's not important enough for how transformative her work was. You can make money on your transformative work. That's okay to do. Great. Excellent. Accordingly, under the analysis of the first factor, the court finds that the defendant's use weighs in favor of fair use. All right. Oh, that was part B. Sorry, I apologize. That was all still the first one. That was all still the first factor. Here is the second factor. I apologize. Nature of the copyrighted work. Defendant avers that the documentary and informational work nature of the nuke favors fair use. The second statutory factor considers the nature of the copyrighted work. This factor recognizes that creative works are closer to the core of intended copyright protection than informational and functional works, with the consequence that fair use is more difficult to establish when the former works are copied. So basically, this is saying that if you made like an animated short and put it on YouTube, that's a very creative work, right? Versus if you put together a video of like facts about like Wikipedia or facts about like Gaza, that's a very informational work. So like reading like an article on stream, for example, something that's very factual is going to have less copyright protections than like watching some animated like short or something, right? And basically what they say here is that the Ninth Circuit has held that a product is creative where it is the product of many technical and artistic decisions. So like an artistic decision here is like me doing this like smoking the cigar bit. That is a purely creative, intentional addition to this video, right? And then with respect to the publication, while a work's unpublished state would weigh against fair use, the converse is not necessarily true. That's not really super, super important here. And what the judge says is, you know what? There are enough creative elements. You have this like little skit here. You put these pieces together in an interesting way. You can have copyright protections. That's it. That's what this says. The only thing that it says here is it is a creative work with significant informational content. And it says, accordingly, the court finds that the nature of the subject work weighs against the finding of fair use because it is creative, because it deserves copyright protection. Versus if like, for example, can you imagine trying to sue someone because like you wrote like the word like, actually, wasn't this the case? Didn't someone try to like copyright demure or something like that? And it didn't like work because that there's just not enough there. You don't get copyright protections for just like using the word demure a lot. There have been a lot of cases like that. Like you don't just magically get copyright protections if you say, no, but I should have it. And what the judge is saying here, okay, you put together a 2-hour video, you got some skits in here, you recorded yourself, you put these pieces in an interesting way, you put some music, you had an artistic direction. Sure, your work can have copyright protections. They tried to the people who tried to copyright the word react. It's like, are you insane? You're not going to copyright the word react, man. No. MLB actually tried to copyright the phrase play ball and lost last week. Yeah. So the only thing that this is saying here is, yes, your 2-hour content nuke has copyright protection. Congrats. Congratulations. You did it. All right. And then, so moving on from that. So that's the only factor that I like, quote, lost. But I thought that was like kind of obvious. No? But anyways, continuing. And also that one's not that important, by the way. As set forth, this factor alone is not terribly significant in the overall fair use balancing. It's not like you have to win 3 out of 4, guys. It's a vibes-based thing. And because the work is so transformative, it kind of doesn't matter that the work deserves copyright protections because my work is new. All right. Next, the amount and substantiality of the portion in relation to the copyrighted work as a whole. The third statutory factor asks whether the amount and substantiality of a portion used in relation to the copyrighted work as a whole favors fair use. The third factor looks to the quantitative amount and qualitative value of the original work used in relation to the justification for that use. And then it cites Haas. It cites Klein v. Haas again. Noting the third factor considers the proportion of the copyrighted work used and how well tailored it was to the allegedly infringing work's proper purpose. No matter how large or how long the allegedly infringing work is, the law is clear, however, that quantity alone is not determinative. This factor circles back to the first factor because the extent of permissible copying varies with the purpose and character of the use. The courts have found that copying another work in its entirety is not dispositive as to infringement if necessary for the intended transformative use. See Klein's case. A great deal of plaintiff's work was copied, but such copying was plainly necessary to the comment and critique. And this is regarding Stebbins' case. Even if the court were to credit plaintiff's claim that Kritosis copied the entirety of the retrospective, that would not be dispositive. Kritosis used the retrospective clips in order to further the live stream's transformative purpose of critical commentary. Finding the entire work necessary for the alleged infringer's intended use, and given the fact this court has acknowledged that this factor will not weigh against an alleged infringer, even when he copies the whole work, if he takes no more than is necessary for the intended use. Here, defendant showed the entirety of the nuke. It is evident that to comment on and critique a work, clips of the original may be used. Parody must be able to conjure up enough, at least enough of that original to make the object of its critical wit recognizable. Copying does not become excessive in relation to parodic purpose merely because the portion taken was the original's heart. The court and Haas recognized that without using actual clips, the commentary and critique here would lose context and utility. So if I'm watching Ethan Klein's video, I'm watching his content nuke. I'm reacting to his content nuke. And the entire time, I'm explaining why he's wrong. How can people understand what I'm explaining without seeing the original? If I'm saying that's insane that he would say that, doesn't he understand this and this and this? The original is necessary. And I would also argue that, like, when you're watching or when you're reacting or whatever to a video, especially when you're debunking, you can't skip pieces of it. Because then what's to say you didn't skip those pieces because you didn't have anything to say about them? Oh, we're not going to look at that. Don't worry about that part. We'll just skip ahead a little bit. What was in that part? Wait a minute. Aren't you supposed to be debunking all of this? It's weird that you skipped that section. What was in that section? You're taking this entire tragicomic documentary in its entirety and explaining why all of it is incorrect. Which is funny because Ethan does it all the time. Ethan skipping sections of the content cop. Ethan skipping the button section. Yeah, I don't need to see that. I don't need to see that part. Accordingly, the court finds this factor does not weigh against defendant. Why? Because I used as much as I needed. And the extent and quality of the importance of the video clips used by defendant was reasonable to accomplish the transformative purpose of critical commentary. Okay, next. This is the final factor. All right. Effect of the use on the potential market. The fourth factor asks, also someone said, is this ruling any different from the tentative ruling? And if it isn't, what was the point of that? Basically, here's what happened. I filed my motion. It's like 10 pages or something. They replied. They replied with 10 pages or something like that. And then we replied again. Okay, so there are 3 court documents. If you go to Court Listener, you'll see those 3 court documents. And then both parties have the opportunity to show up to a court hearing, a federal hearing in front of a judge, and make any last arguments they want to make. And it's also for the judge to say, hey, I'm really confused about what this is. Can you explain? You explain it, and then you can respond. It allows the judge to ask any final questions that he has, and for both parties to say what they want to say. So right before the tentative ruling, sometimes judges will put out right before the hearing, sometimes judges will put out a tentative ruling saying, hey, this is where I'm at. Mentally, I am here. Change my mind. Like they basically do kind of like a Steven Crowder segment. Here's my tentative ruling. Okay, get on the stand and change my mind. So both parties show up to the hearing. They say any final last second argument. Judge asks any questions that they might have, or that he might have, or that she might have. And then they process it and they're like, okay, thank you for your arguments. And sometimes they put out a ruling immediately. And sometimes they don't. Sometimes they're like, they wait a little bit, which in here, that's what they did. Non-jury trial. This is not the trial. This is a motion to dismiss, which is with a judge. Is this defending yourself with an appeal going to cost you anything, or is it purely him pleading with a judge? Yes, it will. And federal court is really long. This is like a really short thing. This is a really short process so far, but federal courts are generally really long. So I was saying, if you would like to donate to my GoFundMe, I'm going to go through, because he said he's going to appeal it. And that'll probably be at least like another year or something. And I would really appreciate any and all support. If you have like $5 or $10 or $20, anything that you might have to spare, I would really appreciate it. And I will continue to fight, and I will continue to give you guys updates the entire time, and then we will fucking win in the appellate court. So yeah, so then the judge puts out the tentative ruling. He allows both parties to make any last second arguments. And after that, you know, he ponders the orb a little bit. The judge is like, and then puts out an official ruling. And then he put out an official ruling, and he made a couple things. He said, you guys said this, I don't agree. You guys said this, I didn't really think that was important. So if you check this, if you look at the difference between this one and the tentative ruling, you'll see there's like a section where the judge says like, I was not particularly moved by this hate watching argument. Hate watching is not really that important when the work is so transformative. This argument about hate watching you made at the hearing, I was not particularly moved by it. Okay, anything else? So yeah, this, and also the tentative ruling is not like official. To be honest, I wonder why there's 5,000 people listening to legal proceedings. I don't even know what this message means. Is there no anti-slap protection or something? Not in federal law. Anti-slap is a state-specific thing. Federal court does not allow anti-slap. There is no such anti-slap for federal court, and this is all in federal court. Where were we? Right. I might play the video again at the end of stream for anyone who's hopping in towards the end. But Jubilee Ethan Klein versus the 20 people he's suing. Shut the fuck up. Stop. Can we reach 6 or 7K viewers? You're sickening. You are a sick person. Mods, get him. Tar and feather him.
Hassan's hot. Oh, I'm gonna fuck him.
Forgot about that. Buyers, thank you so much for the gifts of thanks. All right. How can you appeal after that? It's GG. Well, basically, you're putting it in front of a different judge and saying, Mr. Judge Man, Mrs. Judge Lady, please rule differently from that guy. That's what the appeal process is. That's what the appellate court process is. If that explains. Well, technically, it's 3 judges, I believe. The appellate court is 3 judges. Like a panel of judges. A council, even. So it's a little bit different, but, and it is a higher court, but we're getting a little, yeah. Is this 9th Circuit? I believe so. Okay. Where were we? Yes, we were on number 4. First time chatter, big fan after learning about this bullshit suit. Thank you. Welcome. All right. Where were we at? Right. Okay. So the 4th factor, this is about market. The 4th factor asks what the effect the alleged infringing use has on the potential market for or the value of the copyrighted work. This factor considers the extent of market harm caused by particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of this sort engaged in by the defendant would result in substantially adverse impact on the potential market for the original. So like, think about like all of the people who, for example, watch the like pirated version of Creator Clash 2. Like there was actually a significant harm to the original pay-per-view purchases because of the rebroadcasts there, right? So we care a lot about market harm, but we care a lot about market harm when there is no transformation. When a work is significantly transformative. So for example, if I was streaming, although I wouldn't because I have nothing to say about boxing, if I was streaming a boxing fight, but I keep pausing in the boxing fight and I'm like, okay, so what you need to understand, I'm pausing for like 5 minutes at a time to be like, the technical skill on this guy, what he can do, he can left, right. Oh my God. Wow. That's an incredible move right there. Anyone who wants to watch the fight is going to fucking close my stream and be like, oh my fucking God, shut the fuck up. I just want to watch the fight in live time, dude. Jesus. Because that's now a different product, right? Terrible analogy because of your ability to commit to the bit. Yeah. Denims boxing expert confirmed. And so it's the same idea here where it's like, if the work is very transformative and you're getting a substantially new product, the effect of market harm is not really recognizable because they're so different. So let's see. We'll read this here. Where the allegedly infringing use does not substitute for an original and serves a different market function, such factor weighs in favor of fair use. In Campbell, the court found that when a use is transformative, market substitution is at least less certain, and market harm may not be so readily inferred. Indeed, as to parody pure and simple, it is more likely that the new work will not affect the market for the original in a cognizable way under this factor, that is, by acting as a substitute for it. Thus, where the original work and the new work serve different market function, such that there is no market substitution, the new work is more likely to be fair use. At Denims, I can confirm I had no interest in watching the nuke, but I watched all 4 hours of your response to it. And again, it's like, there are a lot of people that are like, I don't want to watch this content puke. I don't want to like have my ears fucking fall off watching what I know is a bunch of drivel. I would be down to watch somebody else debunk it and talk about all the parts about it that are bad. But for fuck's sake, I'm not watching this trash. I'm sorry. I'm not watching this. And that's what we're saying. We're saying these are different experiences. They're just different experiences. First of all, there are no Ethan Klein fans that are going to watch me over the original video. Why would they? If they're watching me, it's because they want to see what I'm going to say. Because I'm providing something different. There's no one that's watching me that would want to watch Ethan. There's no H3 fan that's watching me instead of Ethan just because they want to watch the original video. They would just watch the original video. If they're watching me, it's because they want to know what I'm going to say. That's why they're watching me, right? Also, don't say that Denims Hassan has like hundreds of hate watchers. Well, yeah, but that's because they want to hear him say stuff so that they can type shit at him. You understand? Anyone who is an H3 fan that's watching my stream is watching my stream so that they can hate on me and hate on what I'm about to say. They're not there to watch the nuke. They're there to watch me. And then there's like, which they try and say like, well, what about the hate watchers or whatever? But again, hate watchers, so people that want to watch Ethan, but they want to hate watch Ethan, it doesn't change that my work is so transformative that the purpose of like any individual viewer is not relevant anymore because the transformative nature of the work is what's the most important, if that makes sense. And then you still also have to prove that all of those people weren't there for my commentary, that someone who was a hate watcher wouldn't want specifically my commentary. So there's 2 different hate watching groups here, but both of these don't make any sense and aren't good enough arguments when we're talking about this copyright lawsuit. Okay. Defendant's live stream is not a market substitute for the nuke because someone watching the former will have a very different experience from watching the latter. Anyone seeking to watch the nuke, a scripted and edited documentary, would have a distinctly different experience watching defendant's fragmented start and stop live stream, which featured spontaneous reaction, live chat interaction, sharp criticism throughout, and extrinsic source material. And then they cite Stebbins' case, saying, finding a lack of market substitution because anyone seeking to watch the live streams would have a fundamentally different viewing experience than a person seeking to watch the retrospective. Anyone seeking to watch the original on its own will have a very different experience watching the reaction video. So if there are people that wanted to watch the nuke, if they tried to watch my stream, they would get mad and leave. because I kept pausing and fucking yapping so goddamn much. Like literally, it was a fucking yap fest. The people who were watching my stream wanted to watch me make fun of the content nuke. That's why they were watching. Or to like clip me because they were like, oh, this, I'm gonna send this to Ethan or something like that, or whatever. There's literally an emote because you pause so much. I mean, certified yapper. I'm legally, I am a certified yapper. Legally. I can't believe there's an official legal document of me saying someone's work feels like a middle school project. That's crazy. Okay. And then it cites this other work, Denim's attempt, and then again, they cite the original statement from Ethan Klein. Indeed, plaintiff's own allegations suggest as much. Denim's attempts to use the nuke for the exact opposite purpose. So he's saying it's a completely different market. She is appealing to people that want to see Ethan Klein made fun of, and they want to see the content nuke broken down. The decision in Hughes v. Benjamin, the court held, is highly instructive. There, the court held there is no danger that SJW levels awareness will usurp the market of progressive commentary, such as we thought she would win. Benjamin's target audience, generally political conservatives and libertarians, are obviously not the same as Hughes' target audience. Moreover, although SJW levels awareness is comprised entirely of portions of We Thought She Would Win, there is no reason to think that Hughes' audience would abandon her progressive YouTube channel to watch the derisively titled SJW Levels Awareness on a conservative YouTube channel simply because it contains parts of her work. So this is basically saying there are no Ethan fans. There are no Ethan Klein fans that were watching my stream as a way to watch the original broadcast. They were watching it because they wanted to see what I was going to say so that they can call me stupid or whatever. Hey, why are you just reiterating court shit though? Because I want to. There's this thing called free will. You should try using it to do things that make you happy. So, yeah. I wanted to. Any other stupid ass fucking questions? It's like I guess when you can't ask, like, how's the lawsuit going? This is what you have to rely on. Hey, why are you just reiterating? Okay, and then finally, because 3 of the 4 fair use factors strongly favor defendant, including the most important factor, purpose and character of use, the court concludes that fair use defense applies as a matter of law. Thus, the motion for judgment on the pleadings is granted. For the foregoing reasons, the court grants motion for judgment on the pleadings. The court orders defendant to prepare and submit a proposed judgment in this matter within 7 days of this order. It is so ordered. And that's what we did, ladies and gentlemen. And that's what we did. Did you guys ever consider that the content nuke backfiring in the worst way possible is also antiseptic? Did you consider that? And it's hummus. It's also hummus. And the document also personally did CPS. This legal squash document. And I gotta play it one more time. Come on, I gotta play it one more time. And then we'll play the very, very end. Did you guys like the Queen bit that I did? Did you guys like that? Graphic design is my passion. I don't know if you guys liked it. I did? Yeah. Maybe I'll just play the whole video one last time. And then we'll head off for today. Shall we? Can this be a new stream intro? Honestly? All right. Let me put this on here. Okay. One last one. We'll run it back. For anyone who missed it at the very beginning of stream. Denims, congratulations on your court win. Thank you. Oh, hey there. It's your old friend, Denims. I have a lot to catch you up on, but before that, a quick message for Ethan.
Look at me. This is me. I win, you lose. And you will continue to lose, and I'll tell you why. Because I'm not done. I'll never be done. Fat L's, cringe, you lose, I win.
Before we start, let me bring in our honored guest. You might have previously known him as the Fair Use King. And let me just...
of like small animals getting eaten by snakes and shit. Sort of primal shit of like a human being in that scenario. Denims does deserve it, so maybe it is worth watching. About that lawsuit, honestly, I feel like they're already fucked, right? And I feel like they're basically cooked no matter what.
Denims raised 15K.
For Ethan, that's nice of her to do that.
The lawsuit asserts that there has to be some kind of like conspiracy with the H3 snark mods, but I've never communicated with any of them in any way. So what exactly did I say that proves this malicious intent and involvement in this conspiracy? Well, here are the clips from his video. We're relying on you to stay live so we don't give more views on the nuke. Yeah, I'm gonna stream it. Since he confirmed it's coming out today, we're gonna stream it. If you want to watch it with someone else who's already watching it, you know, come enjoy the watch party somewhere else. If you enjoyed not giving any views to that terrible video, follow, subscribe, throw a prime if you like the content, if you enjoyed your time here. Compelling. Sorry, director's cut really fast. I highly, highly, highly considered wearing the same shirt. I did highly consider doing that. And honestly, if I had a purple version of that shirt, I would have done it. Right? Here's the thing. I don't care how many views Ethan's video gets. It's just not something that's ever crossed my mind. So in that first clip, when I read that chat message, I answer their question and move on. I hope you guys don't mind me not lambasting that chatter. You literally should have tarred and feathered that chatter. You literally should have tarred them for saying that. The second clip is so plainly out of context that I don't really know what to think of it, especially considering that they also tried to use it in the filing. Let me play the full thing for you. Yeah, this is another thing. Don't go bother Hassan while he's in fucking Japan having a good time. Don't bother him about this stupid garbage. Like, I think it's bad enough to like lose a friend, especially someone where someone you really tried to like make a better person. The last thing I would want while I'm vacationing in Japan is to be fucking linked 100 times some video from a deranged ex of mine, right? If you want to watch it with someone else who's already watching it, you know, come enjoy the watch party somewhere else. It's crazy that they cut those two, that Ethan cut those two parts together, where it's me saying like, yeah, I'll be streaming it, come enjoy the watch party somewhere else. Meanwhile, that second clip is me saying, dude, don't go and harass Hassan and be like, watch it, you need to watch it. Like, I know that when that happens to me and I get people in my chat sitting there spamming a video and I don't want to watch a video, I'm like, dude, stop sending me this video, man. I don't want to watch that video. So I didn't want my watching it to cause more people to sit there and fucking type in Hassan's chat and be like, watch it. Because he's like on vacation, he's chillaxing, doing IRL streams. Why the fuck would he want to watch this video? Why would he want to interrupt his IRL broadcasting streams to watch this fucking doo-doo? Right? And that's me saying, if someone is already reacting to it, just go watch the people who are already reacting to it. Don't bother people to go and react to it. I understand you really want to see what Hassan would say and you really want to see Hassan's reaction, but just watch the people who are already reacting to it. I don't think that needs any further explanation. The last clip is me shilling at the end of my stream. So, you know, after I had just spent the past 4 hours tearing this video apart, what can I say? I thought the video was bad. Whether or not people watch his video is just not something I had thought about at all. If you want to argue about it, the viewership of my stream is totally insignificant compared to his. And nobody that listened to me criticize him for 4 hours was going to watch his video anyways, because it's a completely different experience. And I mean, that is literally what the court found. So all of that to say, there isn't anything uniquely special about this case. Technically, between you and me, even if there was, intent doesn't actually matter. I like how you're watching yourself like a proud mom. I know, right? Why am I like 2 shades lighter? I did shoot some of these scenes at night. I look so tan in this video and I look so white on camera right now. I have like the fucking sepia filter in the other one. It's the same camera. It's the same angle. Like I guess I'm a little bit closer to the camera, which is, I don't understand when it comes to analyzing whether or not something is fair use. So yeah, Ethan posted this IG story saying that he would be proceeding with an appeal. And as I've stated from the very beginning, I will be fighting this lawsuit to the end. I could not have gotten this far without all of your support. And to be honest with you guys, it has been kind of expensive. So from the bottom of my heart, if you would like to help me fight this appeal to defend React content on the internet, please go to Ethan Klein Law and donate or exclamation point GoFundMe
$20,
really any amount that you're able to. Thank you again to everyone who has supported me and believed in me. And as I said before, I look forward to beating Ethan Klein in court. Besides that, I stream on Twitch Thursday through Sunday. at 7 a.m. PST. I also might be doing a mass unban. So if you are one of the morons that told me I was going to lose my lawsuit, you owe me an apology. Come say hi. All right. Bye.
Denims, the queen of self-owning, you prevail again.
You prevail again. It's hard to prevail all the time. Oh, hi, Kilotonics. Kilotonics, how does it feel to be right just right before all of the filings completely vindicated you? Oh my God. I love being right. Oh, Christ. Okay. So yeah, if you would like to help me fight this appeal, please donate. I would really appreciate it. It means a lot. Lawsuits are expensive. Appealing is expensive. And I will promise to just keep being as transparent as possible, keep you guys updated on the appeals process, let you guys know if anything changes, what happens, as I've always been, as I've always tried to be. And as you guys can tell, I am obviously, fighting it. I'm obviously going to fight it to the best of my ability. Another year at least probably in court. Yes. So, and it's only after appeals that potentially maybe legal fees can get discussed. So even if it's just like $1, $5, any amount, it just means a lot. It helps a lot. And with that, everyone, a year of coping. Yep. And with that, I had some other stuff that I wanted to watch. I forgot. Like Fantano put out another video. I saw this like some mantis got like really mad at me. I saw Asmongold coping, and I have to talk about that as well. Also, I'm sorry I missed it. Cat Belly, thank you so much for the 5 gifts. Zap Funksing with the 67 ones. Can we watch the cope? Maybe if I'm feeling brave, guys, tomorrow we can do like an alt stream where I just watch some of these funny memes and talk about it. Maybe I won't. I might not do cam. I just have a lot of like, guys, my apartment is like, it looks like a tornado hit my apartment. I still have everything from like Vegas, which is like basically not unpacked.
My lawyer can't do fucking shit.
I don't think I have a single table that doesn't have random stuff on it. Like, I'm so cooked, guys. I'm cooked. Just not legally. I'm just cooked like cleaning wise. So I have a lot of stuff, and I have a lot of like really cool. I did a bunch of photo shoots that I'm really excited to post, and some great content. I did a Yoruichi cosplay. Not many of you guys saw that, for cosplay enjoyers in chat. And I was like, I am not letting this lawsuit victory stop me from going to Anime Expo. I worked so hard on this gosh darn. True. That's me. Look, it's me. Hey, yo, it's me. So I'll take some like actual like photos. I have like a couple, but I'm going to do like a nice fun shoot with that. Can you guys believe that I got this like wig and I turned it into a ponytail? And it ended up matching my hair color almost perfectly. Isn't that crazy? I bought this stuff and then I drove back from Vegas and I'm like, please be the right color, please. And I checked her, I was like, yes, it's the right color. All of this stuff I'm like looking at, I'm like, please be the right shade. What character is it? It's Yoruichi. This is the character. God of Thunder. But anywho, yes, that is all I have to share with everybody in here. Thank you, everybody, for... Whoa, what the AI? Huh? You think this is AI? Thanks. Oh, thanks. That's really nice of you. Thanks. You're so right. It looks nothing like me. All right. But anyways, thank you, everybody, for tuning in. Why do you have an Iron Lung poster? Oh, because I went to the premiere. It was really fun. But, sorry, I keep getting sidetracked. I haven't streamed in so long. I've been, like, guys, I've spent every minute working for the past... Like, and I'm not joking, like almost every single minute has been spent working for the past like 10 days. So I'm excited to end stream and just like vegetate. I'm probably just going to vegetate on my couch and do this. Just go. I've played like 2 league games in the past 10 days. This is not okay. I'm just going to